and we ask our clerk to please call the roll.
Trustee Abbott,
Present.
trustee Krusek,
Present.
trustee Page,
Present.
trustee Martinez,
Present.
trustee Blair,
Present.
trustee Kagan,
Present.
Mayor Cunningham.
Present.
Quorum established.
Thank you very much, clerk. So we will begin tonight's with a presentation from our Chief of Police on the Safety Act. But prior, there's some statements I would like to make, please. So while the Safety, Accountability, Fairness, and Equity Today Act, known as the Safety Act, officially became law on January 22nd, 2021, there's certainly been a measurable increase as of late in the news coverage of this law, and much information has been published from a variety of sources. And in light of this news coverage, the village board and I understand that some members of our Woodridge community have questions and concerns about the Safety Act. For this reason, the village board and I have requested a public presentation from our Woodridge Police Chief, Brian Cunningham, so that we can share this important information with our neighbors and all who are here that wish to become more educated and informed on the potential impacts that this law may have on local law enforcement within our village. The Safety Act impacts many aspects of the criminal justice system, including pre-arrest diversion, policing, pretrial sentencing, and corrections. Following tonight's presentation, if you'd like to share your opinion about the Safety Act, consider contacting our state and local legislators ahead of the General Assembly veto session, which is scheduled for November 15th through the 17th and November 29th through December 1st. Would like to make mention too that we do have cards available. If you would like to make a statement this evening, you can, if you would take a card and you just fill out, and it gives us a gauge, and we'll know if you want to definitely come up and speak. We will invite you up to the podium so you know when you can come up. Okay, so we would invite you with that. With no further ado, I'd like to invite our Chief of Police, Brian Cunningham. Chief, thank you very much. We welcome you.
Mary, you took over my first slide. I was going to talk all about that. Yeah, this is going to be, it's kind of a difficult topic because there's been so much media coverage on this and it has become politicized. But like you said, it has been, the act had come into a law back in 2021. So what I'm going to do is talk a little bit about some of the timeline and discuss that. And what I want to focus on primarily is how these laws will affect our operations in Woodridge for the police department and also for the residents. So back in February 22nd, the law went into effect. That's when Governor Pritzker signed it. Initially, I'll give you some of my personal opinions. When I first read it, I was overwhelmed with the amount of information was in there. And I always look for the whys, right? And the reason the whys came about is because many people felt the criminal justice system was disproportionately impacting minorities, underrepresented people, and impoverished groups. And I understand the importance of that. But a lot of the things that came out initially, the initial law was confusing to us as law enforcement. There was contradictory language in it, and in many cases it changed. It would have changed significantly the way we operate. So one of those main things that brought concerns to me was body camera language that initially came out. Now we had implemented our body worn camera program in January of 21. This law was signed into effect in February 22nd and 21, so a month later. And some of the concerning things that came up initially was that if you forgot to turn on your body camera, it would be considered a felony, class 3 felony. If you looked at your report or your body camera before filing a report, you could be considered in violation and also subject to felonies. There was all kinds of things there that weren't consistent with what we had already trained for 2 years. We trained for body camera. And the officers were obviously confused. They didn't understand why we're implementing the body worn camera program when all these different restrictions were coming out. And basically daily, I would go to roll calls, talk about this, try to calm them down and say, I'm confident that there's going to be some trailer language to clear this up. Luckily, there was, and I'll talk a little bit about that. Some of the other issues that came up in that initial rollout of is our use of force language, changed the way we operated, put officers at risk. That language needed to be addressed. Law enforcement misconduct, there was ambiguous language there. An unbelievable amount of police training requirements that we weren't doing at the time. We were close to doing it, but created some staffing concerns for us. Anonymous complaints, unfunded mandates with body worn cameras. Luckily, we were already into our program, but a lot of agencies weren't able to fund their body worn cameras in the time frame that the legislation wanted. Class B and C misdemeanors, I'll talk at length about that. That's one of the areas I'm really, really concerned about. Obviously, pretrial release, that's what you've seen a lot in the media lately. And an elimination of qualified immunity. Those were the main topics that came out of it. Luckily, after that, there was a lot of discussions between the Illinois Chiefs Legislative Committee and what the act had come on, it would come in implements on different dates. So the first implementation date would have been July 1st, 2021. So there was a lot of anxiety about, are we going to get some of these laws changed and the language cleaned up before we went to July of 21. Luckily for us, on May 31st, a trailer bill was passed. And in many respects, it cleaned up a lot of that language and made it easier for us to understand it. The body camera review laws were changed consistently with what our policy was and what we were practicing. So that was a great relief for myself and the officers. The requirements for training were kind of spelled out a little bit better for us, that we can handle it. Mental health response reporting, that's when we deal with mental health issues and incidents. That was cleared up. The purchase of military equipment, that was a big topic. Initially, we don't purchase any military equipment, so it really didn't bother me that much. But I know there was concerns about agencies buying surplus military equipment and using them. Use of force restrictions, we got a lot of that language cleared up in that trailer bill. No knock search warrants. This was discussed at length. I've been an officer for a long time. You guys know that. I've done my share of search warrants. I've never done a no knock search warrant. I understand that a lot of big cities do. And I thought the language that cleared that up was good, right? Essentially, you have to do your due diligence. There has to be a supervisor there. You have to be wearing a body worn camera, which I'm a proponent of. So I like that language when it was cleaned up in the trailer bill. Duty to intervene. There was a lot of confusion on this one. It required law enforcement officers to do things that we normally wouldn't do in the course of our duties. That was cleaned up in the trailer bill language, so I was happy about that. Law enforcement misconduct investigation and retention of records. There was some clarifying language on that. And then Attorney General Act, which came into effect on July 1st, that allowed the AG's office to conduct independent investigations and pursue civil action against officers. And they could be fined. The officer can be fined if there's a pattern of practice of misconduct. And there's still some concerns about that and the confusion of how that's going to roll out. But that already went into effect. I'll talk more about that later. So the next date for implementation is October 1st of 2021. And at that point, there was a task force created to review qualified immunity for police officers. The initial due date for review was May 31st of 2021. The task force couldn't meet that deadline. They extended the deadline to December 31st of 2021. There were some recommendations by the task force at that point, but they weren't able to complete the report. So this is, it's not completed, qualified immunity for police officers. So there's a report due by the task force by 2022, I assume by the end of the year. So that's still out there. That creates a lot of anxiety for myself and other officers. Basically, if you're involved in any kind of action, you could be sued. And it could be something that you did innocently, but it subjects officers to additional litigation. The next date of implementation was January 1st of 2022. There was some vague language in the initial law regarding 3 phone calls in 3 hours. That was implemented. there was a lot of discussion about it. I really didn't see the issues with it. Whenever I arrested somebody or whenever somebody in Woodridge arrests somebody, we give them as many phone calls as they want. But I understand a lot of this language and a lot of these laws came about because officers in other jurisdictions may have done it differently than us. So there's a lot of discussion about this. The things I was concerned about this particular point was that if you had an ongoing case and somebody would call somebody to kind of get rid of evidence and kind of impact your case from that point on. But it really hasn't been an issue for us thus far. So. July 1st, 2022 was the next implementation. This was originally supposed to be implemented in January of 2022. However, it was pushed by a trailer bill to clear up some language. I was really happy with this rollout in July 1st of 2022. Some of the things that we had looked for as law enforcement agencies was mental health screening for officers. There was a lot of language and clarifying things that will help us that way. It created law enforcement certification review panel and provided for automatic and discretionary decertification. This is something that a lot of us chiefs really, really wanted. And what you had in a lot of agencies was officers that would get in trouble. They'd do something criminally. And then they would change departments and go somewhere else. And a lot of time that background information never came to the new police department. So one of the things we wanted as police chiefs is to make sure that if there's any kind of issues that way, that we have a avenue to kind of address that. And then, officers that are perceived as bad apples or are bad apples can't jump to other jobs. So that was good language there. New training requirements for probationary and non-probationary officers. Great. I'm always about the training. The difficulty sometimes is us implementing it and having the staffing to complete what we're required to do from the legislation. One of the other things that came out in July 1st, 2021 was allowing ILETSB. ILETSB is the Illinois Law Enforcement Training Standards Board. So all our training goes through them. It allows them to accept complaints from persons who remain confidential, at least initially. So there was a lot of discussion and a lot of concern about taking a complaint at that time from anonymous people for the obvious reasons. And I'll talk more about this as we move through the presentation. July 1st, they also implemented officer professional misconduct database, and that's another avenue to make sure that the officers that we have in the state of Illinois are true to the profession. So now we go to January 1st of 2023, and I think that's what everybody has been, well, I know that's what everyone's been concerned about. But I just wanted to give a little background just to explain that this has been around for over a year. And now we're just hearing about some of these things. So you have to be careful about the sources of your information. I encourage people to dive deep. There's some bad information out there, but there's a lot of good sources. And you should look for multiple sources to get the right information. So moving into January 1st of 2023, some of the things that are going to be implemented are resisting and obstructing language that clarifies what these two offenses are. It's kind of discerning that we couldn't figure this out earlier because this seemed pretty easy to me. And basically is if you have a resisting case, there has to be an underlying offense, right? The language in the initial rollout didn't really clarify that. But when they clarified it, it was pretty obvious to all law enforcement. And obstructing, you don't have to have an underlying offense. But we had talked about that for months and months on end and finally got to a conclusion on it. Another rollout that's coming out in January is anonymous complaints. And at this point, it's allowing for anonymous complaints against police officers. And what they can do is complain directly to ILETSB. That's our training organization. ILETSB has the authorization to investigate and initiate these certification proceedings. I'm concerned about this portion of the law, basically because we do get a lot, we don't get a lot of complaints, but when we do, I always have an opportunity to talk to that person who's complaining. And what I have found is that when we're transparent and we actually have a conversation about what happened, and I invite somebody in to look at the body worn camera, we develop a relationship. And oftentimes people that have joined our Citizens Police Academy. They've joined because I've talked to them about a complaint and they want to know more about the police department, and it ends up being a positive rather than a negative. When you don't know who's complaining, it's difficult for us to deal with. So. I look at it as a lost opportunity to clarify any law enforcement procedures and develop relationships. Okay, now we're going to move to citation in lieu of arrest. And I mentioned earlier, this is an area of concern for me. Citation in lieu of custodial arrest, law enforcement shall issue a citation in lieu of custodial arrest upon proper identification for those accused of traffic and Class B and C criminal misdemeanor offenses. There's a couple words in there, and I'm sure Eric will agree with me. The shall, to me, is an absolute in legal language. There's no ifs, ands, or buts. You shall issue a citation. So as we move forward in the presentation, I'll raise some of the concerns I have with that. So when we talk about the actual offenses that we're discussing here, is the Class B and C misdemeanors and below that. So they're low level offenses. So on the surface, you would think, okay, we definitely want to make sure that maybe those offenses should just receive a citation rather than arrest. But these are sometimes the most difficult cases we deal with. It's your disorderly conduct cases. It's your trespass cases. Those are two big ones for me. Telephone harassment, possession of cannabis, aggravated speeding, obstructing service of process, littering, picketing of residents. In many cases, these kind of incidents actually involve mental health issues that we have to deal with. So we struggle sometimes when we're dealing with these cases. This following is this is a chart that came about from the Supreme Court appointed task force that's involved in the implementation of the new laws that are coming up in January. And there's a couple of things I want to point you to. One is there proper identification? There's really no clarification of what that means. It could be you need your driver's license, or it could be somebody that we know. So I'd like that clarified before January implementation. Another thing that's concerning to me, does this person pose an obvious threat to the community or any person on the surface? That may seem easy to figure out. I could tell you from practice that it's not. Sometimes there's a thin line between someone who's maybe someone who's a threat to the community or someone who's expressing their constitutional rights. So that's something we're gonna have to deal with as a police department as this rolls out. So I'll talk a little bit about what happens in Woodridge, especially when it's concerning criminal trespass and disorderly conduct. In 2021, we had 40 incidents of criminal trespass. And when we see criminal trespass, it's usually related to the column next to it: mental health, suspicious persons, domestic related, past threats of violence, past incidents of drug-related activity. And the locations that we usually find these offenses is multifamily neighborhoods. A lot of times the apartment management will run across somebody that's either living there or not living there anymore, that may be involved in drug activity, gang activity, criminal activity, and they want to trespass them. They call us. We give them the trespass notice. We ask them to leave. If they come back, they're subject to arrest. A lot of incidents occur on Park District property. It's that call that we get that somebody's suspicious. They're hanging around the playground. There's kids there. They're concerned about it. And we'll get called to that incident. We actually talk to the person. We'll give them the criminal trespass if that's what the caller wants. And then we tell them that, hey, you can't return to this area. We get a lot of these calls at the library with people who are disruptive at the library. We'll actually give them notice, and then they're subject to arrest. Moving forward in January, that won't be the case. But the one thing I want to point out, we had 40 incidents in 2021, but we only made 7 arrests. So I could tell you right now, be assured that the officers in Woodridge utilize every means to avoid arrest in these situations. We recognize that in a lot of instances, it involves mental health issues. And I'm amazed and proud of the officers' efforts in trying to avoid arresting somebody and finding proper resources for these people that are struggling. In a lot of cases, the arrest only comes because it's the last resort for us. And sometimes that stops the actions. So disorderly conduct, in 2021, we had 81 incidents, but I could tell you it's probably 3 to 4 times that, depending on how the call is classed. It's definitely more than 81, but we only made 8 arrests. So that shows you that we're not looking to arrest people in these situations, and that we're trying to utilize every means to find another way to resolve it. But when we're talking about disorderly conduct, it's breach of peace, threats of violence, domestic situations, suspicious persons, and it oftentimes revolves around mental health. One of the cases I'd like to talk about is in 2021, and I have talked about it in front of the board before, is we had an individual that daily was dumping garbage, urinating in the hallways of his apartment, tipping over flower beds, all kinds of things. We had contact with that person at least 20 times in a 2-month period, and he was arrested 3 times and after exhausting every means possible to get him the service that he needed. Oftentimes we were able to get him to the hospital for assessment, only to find out that within hours he was released and back doing the criminal activity, low-level criminal activity. But eventually we were able to help that person through the system. And for that 2-month period, although it was daily and sometimes 3 to 4 times a day, we were actually getting called for disruptive behavior. We haven't had an incident since then. So, I mean, and one of the officers that was involved with that was recognized as the employee of the quarter. So our officers are prepared to deal with that, but unfortunately, there are times when it's a last resort to make an arrest. And a lot of these low-level crimes, they lead to bigger things. And when you talk about hate crimes, for that matter, it usually starts on a lower level through disorderly conduct. Stalking crimes usually start where somebody's following somebody, or they're peeping in their windows, following them in their car. That's a disorderly conduct. And sometimes these arrests kind of stop that from happening, any future incidents. So some of the things that citation in lieu of arrest, the challenges that we'll see, the statute doesn't define proper identification. I talked about that. Do they have to show you a driver's license, or could it be obvious that you know who the person is? Most of these people that we're dealing with, we know who they are. So I would think that that would be the case, that we would move forward. They have to be an obvious threat. And I said, this is difficult for us sometimes to discern. Just because they're disruptive, does that mean they're an obvious threat? Say the person that maybe it's last call at a bar and they don't want to leave. Are they an obvious threat, or they just don't want to leave? In those cases, we would just show up, write a ticket, they get a notice in 21 days, and they'd have to go to court. Obvious medical or mental health issues. This is really difficult for us to discern sometimes as well. We're very well trained in crisis intervention, but to actually say that someone, you have a mental health issue, you have to have something to support that. And my concerns is that if you don't have that support, it's going to put the officer in the village in jeopardy if you can't prove that in court. Some other issues we're going to have with this is law enforcement needs to create guidance to ensure consistent application. It's going to be difficult for us. Every situation is completely different, and I'm not sure how we're going to have consistent application in Woodridge, let alone other agencies. Law enforcement must consider how best to refer people to treatment. Sometimes sometimes you make arrests, that's the best possible way to intervene in someone's life. One of the things I was involved in before I came to Woodridge was a program called Connect for Life. And in that program, I was dealing with heroin addicts and their family members, their loved ones. And oftentimes I would hear from them that the best thing for them was to go to jail or be arrested. And that's what changed their lives. So if the B and C misdemeanors comes in effect, I think it'll have a negative impact on some of the ability to kind of change people's lives around. Law enforcement must coordinate with the clerk's office on court dates and proper documentation and forms. We're not even close to that. I really don't know the answer to that. As we move forward, hopefully through the state attorney's office, we'll figure out that coordination. Court dates is going to be really difficult for us. The officers have a lot of court dates already. I would suspect that this new law and the pretrial fairness would probably triple our court date appearances for officers. All right, release for custody. from custody. A person arrested with or without a warrant for an offense for which a pretrial release may not be denied, may accept or otherwise provided in this code, be released by the officer without appearing before a judge. This portion of the law is completely opposite to what we've normally done. Whenever there's, especially with a warrant, whenever there was a warrant up until today, you're commanded to make an arrest, right? And that person who has the warrant has to go in before a judge. Moving forward in January, the officer would have the option to release that person, which could potentially subject us to some civil litigation. If we did release somebody who was wanted on a warrant, and I can imagine if they did some violence, I'm sure there would be an attorney on the other side of things that would say that, hey, we didn't make the right decision in that case. So there needs to be some clarification on this one as well. This is the flow chart that came out through the task force. And a lot of this involves this one, the communication once arrested, the phone calls. I kind of addressed that. We've never really had an issue. I've never had anyone complain that they didn't get their phone calls. I'm sure it has happened, maybe in larger jurisdictions that somebody didn't get their phone call, but a lot of this flow chart centers on the communication for the person that's under arrest. And then this kind of takes you through the release of custody process there. You don't have to bring it through to a judge and we would make that decision. A lot of things come into factor here for a police officer. You're working a 12-hour shift, you make an arrest at the end of the night. You have to figure out, is this a case that you can release based on pretrial fairness? And if you do, what are the impacts to a potential victim? What are the impacts to the village civil litigation wise? There's a lot of factors here that I think still need to be cleared up. And hopefully a trailer bill will be coming forth on that. Like I said before, I always try to think of why the changes in this. And you know, from my research, the pretrial detention of anyone for any length of time is harmful. And I agree with that. It can disrupt a person's employment and family ties, definitely. Research demonstrates that people detained pretrial are more likely to have worse outcomes. Data shows that destabilization resulting from even short detention actually increases a person's risk of recidivism. If we move to this formula, reduces unnecessary cost of the system, frees up law enforcement to remain on the street. I'm not too sure about this one. I think it's going to really tax us. And we're going to have to change things. And I'll talk a little bit more about that. Establishes presumption of release from custody for offenses that are not eligible for pretrial detention. And it'll allow for greater access to phone calls and communication with people while in custody. To be clear, I don't want anyone that shouldn't be in jail to be in jail. I would do anything to get them released. I think the pattern and practice for the Woodridge Police Department is that. We often deal with people on the street, whether it's misdemeanors, sometimes felonies, and we try to figure out the best way to deal with it. We never really want to totally impact their lives. And it goes down to even towing their vehicles. We try to avoid that at all costs. We want to make sure that if someone's productive, they stay productive. But my concern is if there's a safety concern for somebody, they may need to be in jail. The challenges in this situation are similar to what I cited earlier. Law enforcement organizations need to create guidance to ensure consistent application of the law. That's going to be a big hill to climb for us. There will need to be established ways for referring people to treatment. This is a huge thing that we don't really talk about when you talk about treatment. And I talked about it with that Connect for Life program. Sometimes the only treatment you get somebody because they don't want it, right, is through custody. And I know that the DuPage County Corrections Institute has treatment programs for anybody that comes in, not only drug treatment. And I know the sheriff has said at least 60% of the people that come through his jail have had or either on drugs or have drug issues. So immediately they're assessing that and trying to get them into treatment. And right now in our society, that may be the best option for us. I can tell you that it's hard to get somebody through treatment. Sometimes they don't want to. Sometimes they can't get to it. And sometimes, in my opinion, the best effort is through arrest and having them sit for a couple of days and kind of figuring things out and getting the help that they need. Also, when you think about treatment at the jails, I know they have a JOG program at DuPage County Jail. A lot of people get training. So when they do get out of that situation, they have some skills that can help them. So there's a lot of things that need to be considered that I don't think were considered along that lines. Law enforcement is going to have to get with the clerk's office, we'll have to straighten the coordination and deal with our court cases. You know, when you think about an officer working a 12-hour shift, they're probably going to have to go to bond court immediately. They will have to, because we're going to have to prove clear and convincing evidence that that person needs to be remanded into custody. And the interpretation of the right to communicate, and this goes back to the phone calls. Like I said, we really never had an issue of it, but there's always that concern that somebody makes that phone call, and it could be a homicide investigation, that they're going to call somebody who's going to you know, get rid of some evidence that's involving in the case, or they're going to call somebody a victim, intimidate that victim. So I'd like to see some clarification on that language. Pre-trial release. Okay, this is what everybody's been talking about. This is what you see in the newspapers, and I'll try to explain it the best I can. When we talk about the first column, second-degree murder, arson, kidnapping, intimidation, aggravated fleeing and eluding, threatening a public official, in order for, those are all felonies, so we would arrest that person, we'd bring them to jail. But in order for them to stay in jail, there has to be clear and convincing evidence that the defendant poses a real and present threat to the safety of a specific identifiable person or persons. Now, there's some language in there that obviously needs, it's interpreted, it has been interpreted both ways, but the thing that I'm concerned about is specific identifiable person. And the reality of it is that you're working a 12-hour shift, you arrest somebody on one of these cases, the officer is going to have to do immediate research. It's going to involve the body worn camera. It's going to involve subpoenas. It's going to involve search warrants for phone records. It's going to involve extensive interviews with family members or anybody who is at risk. And we're going to have to present that evidence to court with almost immediately, like that day. It's really going to tax our staffing. It's going to tax the officers. They're going to spend a lot of time in court, and then they got to double back and come back for another 12-hour shift. So there's some language there that's concerning. We've seen a lot of media coverage on this particular part of it. People talk about it being the purge. I don't look at it that way. I just think this is something that really needs to be clarified. Now, when you look at the second column, drug-induced homicide, aggravated battery, burglary, robbery, aggravated DUI, drug offenses, hate crimes, in order for a person to be retained into custody for this, they have to be a high likelihood of a serious flight risk. That's a high bar to hit. And that's the state's attorney's office. And when I say state's attorney's office, it really means the police are going to have to figure out what that serious flight risk is. And short of there being airplane tickets or plans that we can prove, or they actually admit it, those people will probably be released. And that's going to be difficult, right? Because then we're going to deal with, you know, you arrest somebody on a burglary, and then, you know, within a few hours, they're released back. That's going to re-victimize victims. There's going to be a lot of issues that way. When you think about hate crimes too, I talked about those low-level crimes that lead to a hate crime charge. I can't imagine that somebody is arrested for a hate crime and then they're released within a couple hours, and what that does to the victim, and does that embolden the actual offender to do more crimes. Here's another flow chart that deals with this. I also made a copy for you, and it basically, some of the things that I'd like to highlight on this is that we have 48 hours to kind of go through this process. It has to be immediate. And like I said, it has to be clear and convincing evidence that this person needs to be retained. The burden of that is on the police department, right? We're going to have, and a lot of it's specialized intelligence information that usually only detectives are able to get or have training for. But it's going to put a huge burden on our police department and our staffing to get the evidence that we need in order to retain somebody in custody. Challenges are the measure of risk when we have to assess the measure of risk to a victim and potential additional victims. Notification of the victim. There's nothing worse than having somebody arrested and us not explaining to the victim what's going on. I never ever want to do that. I don't want our officers to do that. It's going to be a huge deal for us. And then when we have to call back the victims and say, hey, we did arrest this person, but they're out again. That strikes fear in people that we'll have to deal with and kind of deal with as we move along. I talked about time sensitive evidence collection, and that's going to be a huge, huge undertaking for us. Additional court obligations, notification to victim and providing support that's needed. That's going to be something that's going to be huge for us. And you know, I always think about the mental health concerns of our officers, right? When you're working 12-hour shifts and you're staying an extra 4 to 5 hours in court, that's going to affect their personal lives. That's going to affect their work lives. And that's going to be hard for us to manage. And then overall, the potential for apathy. I can't see how we can avoid it. But sometimes you work hard on a case, you do what's right, by the victim. And then within hours, the offender is out again. And that's definitely going to have an impact. I spent a lot of the research I did was through the pretrial implementation task force. And this task force was developed in 2020. It had it still does 6 subcommittees that cover communication, education, and training, legislation, pretrial assessment tools, guidelines, and pilot sites. They've had a huge, huge undertaking with this law, trying to figure out the best way to implement. They assist with the implementation of the systems, which include clarifying some of the matters, particularly as it relates to detainable offenses. And they have tried to make sure every county is equipped to provide pretrial services. I'm not too sure they're successful with that yet. We have a long way to go. But one thing that, as I'm going through the information, that the task force head, the commissioner, had this quote, and it's actually in their website. You can just look it up. It's frustrating because many aspects of the statute are not clear. They may be vague, gray areas. And again, we are charged by the Supreme Court to assist with implementation, not the interpretation or changing the language. And that comes from retired Judge Robin Stuckart. He's the chair for the pretrial task force. So even, I mean, everybody looks at a lot of the aspects of the law, even though there's good things there, there's a lot of things that need to be clarified. And that's the frustration moving forward, getting everybody at the table to talk about these things. And this is the frustrating part for me. So there's a lot of states that are looking at changing their criminal justice system, in particular the cashless bail system. California, New York hasn't been too successful. Pennsylvania, Kentucky, New Mexico, but New Jersey in 2017 had a referendum. By all accounts, all the involved parties talked about it, talked about before implementation, what were the impacts were, and they came up with a system that actually has been working. I encourage anybody to look up their actual cashless bail system. There's a lot of articles, a lot of information on it. And some of the things that they left in place were the prosecution. You could detain a person for any crime where the prosecution proves that the defendant will not appear in court, right? If somebody's not going to show up in court, it's obvious that they probably need to be in jail. And that leads me to another thing. When we move towards warrants, like if somebody doesn't show up, as we move to January 2023, if someone doesn't show up to court, there's no warrant issued, right? A summons is issued, a rule to show cause. So you get another court date, and then that person has to be served with that summons. I think it's 48 hours before the actual date that's set. And if they don't want to be served, it just kind of goes in limbo, and the case doesn't get resolved. So in my opinion, if someone doesn't show up in court, they really don't want to be served. So they'll do everything they can to kind of avoid that service. But going back to New Jersey, if someone poses a danger to any other person or the community, they could be retained in custody. Or if they attempt to obstruct justice, threaten, injure, intimidate, or attempt to threaten, injure, or intimidate a prospective witness or juror. Like I said, by all accounts, the system is working for all parties. It's not a perfect system, and you'll never get a perfect system. And to me, it's disappointed that we didn't look to this, the New Jersey model to try to emulate it and move forward. And maybe we'll get there. I hope that's the case. But to me, if you look at, there are issues with cashless bail. We want to make sure that the disparities are addressed. And I think New Jersey did a really good job with that. I know I covered a lot of stuff. I know there's probably a lot of questions. Maybe I can answer them, maybe I can't. But if anybody has one.
Thank you, first of all, Chief, on behalf of all of us in our community. This act was over 800 and some pages. If anyone has taken a look at it, it's extreme. So thank you very much for providing all the information. And we are going to have this information, Administrator Stonich, right on the village website as well. And again, want to just share, we will also include the information if you wish to reach out and contact our legislators and just ahead of the veto session for the General Assembly. And those dates again are November 15th through the 17th, and then again, November 29th through December 1st. So thank you again, Chief.
Thank you.
We will get to questions. So I think should we just going to first ask our board members, and then we're going to move to public comments. So if any board members have any questions for Chief Cunningham, please.
Mayor, I have a laundry list of questions.
It's 800 pages.
Mine is only 600
Mhm.
for you. What specific plans does the department and the village put in place to protect the safety, well-being, and livelihood of these officers?
Right. As you look at the act, there's a lot of things that we have to do. One of the things that we have been doing, we've done a really good job in Woodridge, is training, right? Our training requirements were outstanding, but now in addition, we're going to have to make sure we do above and beyond. One of the things we've been focusing on in our training is scenario training. Try to recreate any kind of situation we come across, but obviously every situation is different and you can't train for everything. But we're doing our best to look at our best resources to provide training for the officers. Policy, we've worked hard on policy in the last 3 to 4 years to make sure we have the best policy. And not only, I've talked about this before, not a policy in a book, but a policy that actually people understand and actually live, right? So we talk a lot about that. You know, when we talk about the what ifs, I'm big on what ifs. Whenever we have a situation that happens across the country, it could be a school shooting or whatever, I'm always like, okay, this happened to us today. How are we going to handle this? Those are the things we've been doing. We have to step it up in the training part and the documentation of the training part. That's something I'm concerned about. It's just hard and laborious to make sure we document all that training and the training that we previously had. And I could see us, I know I could definitely use somebody that's actually just a training officer that helps us facilitate and actually the documentation of it. And moving forward, I think there's going to be a lot of civil litigation that we're going to have to deal with. And I want to make sure that our officers are protected and we have the information that we need to kind of show that we have been training, that officer is trained. And here's the documentation.
Chief,
A lot of times, if I can add to that, a lot of times we do informal training. And the officers are really good about that. So in roll call, officers will talk about a situation and they'll actually, hey, I did it this way, or I did it that way, or hey, I had this issue with this guy that had a weapon and this is how we handled it. And we talk about that every day, but we don't always document that. And I'm trying to get the officers like, hey, we need to document that. And you have to have people sign it. And that's where it's like, oh, really? I'm like, yes, we have to document that stuff. So getting the culture to change that way, the documentation part is going to be a huge undertaking for us.
I have a follow-up question to that statement.
But,
Trustee Blair has
I will,
a.
No, I'm sorry.
no, go ahead. I have more
Well,
questions, but if you have a
No,
follow-up.
it's related to the training.
Mhm.
So I know how hard you and your staff works to train new officers and all officers.
Mhm.
Will the village need additional assistance above and beyond you and your key members of the staff
Mhm.
to make sure that we cover the proper training required by the officers? That's my question.
Yeah, the big part of that is implementing, facilitating, and documenting. Right now, I use various people, officers who actually have to go out and work the street, but they have a side duty as a trainer. My deputy chief is the training coordinator, but he's got all these other duties to do too. To have a dedicated person
That's
just
my
dealing with that is something that we definitely need moving forward.
Well, going off of that question, a lot of these things that we're talking about are expensive. What is Springfield doing to help? And I'm not saying they're all bad things. I'm saying that training is always good, but we're taking officers and some, as we all know, sometimes we don't have enough now on the street. And now we're asking them to do all this other stuff. You've got them working 12 hours and then staying longer. That's an officer safety issue for me, and it should be a concern to every single person in this community. Who's paying for all this? Where are we getting all this money?
Mm.
It has to be done. Where is all this money coming from?
I did say that I won't be able to answer all questions, and I don't think I can, I don't think I can answer that. So I look at it as, okay, how can we do it the best way we can? I utilize the resources that we have, and this is not the right answer that you're looking for, right? The money's not there, right?
It's
So,
not there, so.
but we have to do the training.
We have to do, so we're taking
Right.
them from here,
Mhm.
putting them there.
Yeah.
So we may not have the coverage on the streets that we should be having.
Yeah, most definitely. That's a problem moving forward because a lot of this training is pretty involved. And even our firearms training, we go off-site. So it takes us a good half hour to go down to Joliet, shoot down there, do our scenario training. We can only do it at 2-hour increments because we can't take the officers off the shift that long. So just our routine training requirements are hard to manage, but now the additional stuff is harder. Scenario training, we have to do that. A lot of it, what I'm doing is utilizing the experts that we have on the police department and also through Merit, the task force. I'm just looking for resources that way to bring people in to train us up that way, but it's difficult.
Do you anticipate we're gonna need more officers?
Oh, yes, yeah.
And how do we do that when we have hardly anybody applying now? In light of this Safety Act,
Mhm.
You are getting fewer and fewer applicants.
Right.
So it's a question that I know that you can't answer, but it's a question that every single resident should be asking themselves.
Right.
I can see my colleague down there, Greg. You look like you had a I have a whole list, so we'll never get through it today.
Well, I mean, I had a couple of questions.
Well, I could address a little bit if I can address your question. Yeah, the applicants are low for everybody, right? We just finished our application process for entry level. We had 65 people apply as of today. I was ecstatic that there were 65 people, but I know there's at least 10 that are friends of my kids that I was nagging for 2 weeks straight to apply.
But how many of that 65 actually are qualified to make it through the
Yeah.
process?
Yeah, that's what we'll see. I would expect maybe 50 are qualified. How many will actually take the test? Probably 30. And I'm
many-
happy with that number, which is sad to say, right? Because it used to be hundreds. that
And not
would
all
apply for this
30 will
job,
make it through the process.
Right? We just let go a couple probationary officers in field training, so.
I want to follow up on what trustee Blair said real quick. We're in budget season, so knowing that there's these new requirements coming 2023, was there extra money built into the fiscal year budget to cover some of these things?
Yeah, specifically the training requirements. We upped that to try to help us with those issues, so.
Go ahead, Greg.
Chief, I just have a couple of questions. You know, you're quite the optimist, and I like that about you when you talk about things need to be cleaned up. But this bill has been in effect now for over a year. What is it, a year and a half, maybe 2 years?
Mhm.
And it's my understanding that police chiefs, state's attorneys have been pleading with Springfield for that length of time to fix these problems, and they've done nothing. I mean, am I wrong on that?
There's been a lot of discussions, a lot of people asking to get to the table. We did get those trailer bills, which I was optimistic about initially, but it's been difficult.
Okay,
Yeah.
but I mean, it hasn't happened. I mean, we've had a
Right.
year and a half where people like you have been trying to tell Springfield, these things are going to be problems that are going to be on my doorstep. We need to fix them. They haven't done it.
Right.
So, I mean, hopefully they'll see the light.
Yeah.
But I'm not optimistic because they've had a year and a half when all of these problems that you point out, it's my understanding, were pointed out by police and state's attorneys early on.
Right. From the onset of the bill coming out, these issues
Right.
were raised. And it's difficult when things get politicized, right? When the right thing to do is just sit down together and figure out a way to get what we need to accomplish done. And it's been difficult.
Well, and part of that, and correct me if I'm wrong, is that because state's attorneys and police chiefs weren't brought into this before the bill was passed. You were shut out, you were cut out. This was a backroom deal.
Mhm.
And what happened was it was passed without your input, without your, the different viewpoints that could have made this a better bill from the get-go.
Right.
So, I mean, I guess my problem is that if Springfield usually has a process where they have hearings, they get all stakeholders to the table, let them all give their view on legislation so that you get a better product.
Mhm.
They didn't follow their normal procedures here.
That's why I kind of, I cite the New Jersey model where there was collaboration throughout before, in the middle of it, and then when it was implemented. I think that's what we need to move for, right? And everybody that's involved has to be at the table. That's the important part of it because, you know, somebody may think this is a great idea, but when you bring up the other things that could affect it, that needs to be addressed. So it's been difficult, yeah.
Yeah, and I always want to go to your, you made the point about how now if someone doesn't show up for court, a warrant is issued for the person.
Yes,
Now, am I correct that if a warrant is issued, then that their name and information gets into a database
yes,
that all police can tap into?
yes,
So for instance, you may stop somebody for speeding, but if you run their driver's license, you may find out that there's a warrant for them in a particular county.
yes,
But what happens now in a situation where you've mentioned that you've got where if somebody doesn't show up, there's going to be a summons issue
yes,
and it's going to have to be served on the person.
yes.
And is that going to be served by Woodridge Police?
Yeah, the way I read it, it's a civil action that probably the sheriff's office will have to serve.
Okay, so they're going to have to go and try to serve someone. And if the person is trying to avoid service, they may never be served. My question is that let's take a situation where someone is not detained. They fail to show up for court. And the sheriff is unable to serve them with the paperwork.
Mhm.
Now, if you were to stop that person after that for a speeding violation, is there anything you're going to be able to pull up to show that that person that didn't show up in court?
As of now, I don't think there will be. Yeah, but will that change in the future? But as of now, no.
I mean, they've
Yeah.
had a year and a half to
Yeah.
fix that.
Yeah, and like I said,
So-
if somebody doesn't show up for court, they probably don't want to get served either. So it's going to be difficult to get those people back into
Well,
court.
and I mean, I can tell you just in my civil practice, serving people is not easy. I mean,
Right.
there's oftentimes people have to, you have to put a car out for days trying to
Yeah.
get somebody.
You know, one of
um,
the things that's concerning too, when you're serving people with paper or even trying to serve a warrant, it's probably one of the most, could be one of the most dangerous thing you do as a police officer, right? You're going to someone's house, you're knocking on the door, you're trying to serve them paper. You don't know what you're getting into, right? There could be a lot of issues in that home. There could be some mental health issues and it puts officers at risk. So,
But one other question I have, and then I'll pass it on to others, but the issue that as far as in order to detain someone, and I understand there's different standards based upon what the charges are, but it's my understanding that there's a 48-hour window for the state's attorney to prove by clear and convincing evidence of what they need to prove.
that's
That
correct.
person is going to be a danger to a specific person or to the community at large. But I mean, do you normally get all your evidence together in 48 hours?
Absolutely not. No, it's difficult.
I
Like
mean,
said.
do you foresee there will be times where if you had a week to gather evidence, you would have been able to meet that standard, but you won't be able to because you only were given 48 hours to do so.
Yeah, even a week is a difficult time. I mean, we're dealing with, every case we have involves, electronics, whether it's phone or computer. And to get that information, oftentimes takes months.
How long?
Months.
Okay. Okay, I'll pass it
Well,
on to.
bouncing off of your question. oh,
Let me
sorry.
just, if you don't mind. So just so everyone knows, we do have a village board meeting that would start at 7 PM normally, but this is important. And I want to be sure that we have everyone that is here, that we do provide an opportunity if you would like to make a comment. So we're going to go ahead and continue, and we will start our board meeting after we are through. Okay? So thank you, and I'm sorry to interrupt, but please, trustee Blair.
Going off of what trustee Abbott said, are there any plans then to increase the number of detectives we have? Because we have, what, 3 now?
Right. My current plans, because we have some staffing shortages, is to reduce investigations. We're looking at some in January, probably a couple of retirements. And the way I'm looking at this now is the best way for us to manage this is to have boots on the ground, right? We have to patrol is our bread and butter, right? If we're not there for patrol, we're missing our mission. So my plan is to staff patrol to the fullest extent possible, and then supplement them when we have to deal with these issues of gathering evidence with tactical officers, because tactical officers are kind of a hybrid officer. They're actually on the street. They can actually help in the moment and help us relieve some of those burdens on police officers or patrol officers. And they also have that investigative ability. So yeah, moving forward, I might have to reduce investigations to get enough support for patrol.
And that's gonna hurt the ability to get all the information by 48 hours.
Right. So the whole idea is I have 48 hours to get the information I can, and how can we manage that? It's not the best system at all, believe me.
I want to go back to the anonymous complaints. Correct me if I'm wrong, okay? From what I've read, if somebody makes an anonymous complaint and it turns out to be unfounded, that does not get expunged from the officer's record?
Even in our own records, anonymous complaints, we track them. And that's the concern, whether it's the category that is it unfounded? Is it just, that's what the classification would be. It would still be there. But you have to look a little deeper. And a lot of times when an officer is in trouble, they'll say, especially in Chicago, they'll say, oh, this officer has 25 complaints. Well, you know what? 23 of those may be unfounded, but you never hear that part in the media. So it's just a matter of semantics on how you look at the language.
So what are we doing to, for our officers, to support them? I mean, they're out there, they're shorthanded. They have to be social workers. They have to be mental health workers. They have to serve and protect. And then they're going to work a 12-hour shift and go to court. What are we doing for them to help them?
Right. The best thing is to provide them the training that they need, develop strong policies. There's not a night that I don't wake up. It's usually at 3 o'clock every morning thinking about, well, what if something happens to the officers? So as a department, we try to do as much as possible.
And then I would like to know what we as a village and the police department, a lot of talk has been about the qualified immunity. If this goes through, simply explain it to me, I think it's akin to a doctor having malpractice insurance. We don't pay our officers enough to carry extra policies. What are we doing as a village? I think that's something we need to talk about before it happens, if and when it happens,
Right.
and as a police department.
The qualified
It might be helpful if you define it first.
Yeah, qualified immunity, and let me give you an example. So we're protected in certain situations, if something happens, right? But if you remove qualified immunity, it could be as simple as I'm out directing traffic, and for whatever reason, I direct somebody right into another car and they crash, right? Someone could say I was negligent, and instead of like suing the village, they would sue me individually. I have been sued individually before. You could do that in federal court. There's a method to do that, but to add the removal of qualified immunity just adds to that.
Yeah, Chief, just to underscore that a little bit, the doctrine of qualified immunity makes officers or anyone who has qualified immunity immune from suit or immune from liability unless certain standards are met. So there are certain things called absolute immunity, which means you're immune no matter what. Qualified immunity means unless you did these category of things, which are usually willful and wanton, intentional, et cetera, you are not going to be held personally liable. So if that goes away, then again, in a situation where an officer is merely negligent and an injury occurs, they may have some individual liability, whereas before, under the doctrine of qualified immunity, being merely negligent, and the chief's example is a good one. You weren't negligent in perhaps shooting someone or beating someone over the head. We're talking about something as basic as directing traffic or pedestrians across the street or any number of things that officers do all day long, which don't involve significant violence or the potential for violence.
That also goes to what I've read that's in here. The Attorney General of Illinois can arbitrarily choose to fine an officer. Correct?
Yeah, the law allows the Attorney General to do an investigation. They have subpoena power. If they find a pattern of practice of constitutional violations, they can fine you. I think the initial one is $25,000. If there's a
It's
second offense,
subjective
Yeah.
under their definitions.
they would be doing the investigation. Yeah. And then the second offense is $50,000.
Trustee
Got a-
Martinez?
Question maybe for Attorney Pat.
I'm happy with that.
Given everything that we heard and the concerns that we have expressed, both by yourself and the board, is there anything that can be done to modify the requirements of this act before January 1st or whatever date?
So what can be done is a legislative solution. There are, there's some litigation that is pending and there may be more litigation pending about the constitutionality of the act or certain provisions of the act. I am of the opinion that those are probably not likely to be successful. But I would say that the legislative solution is not one that can be dealt with at this level. It's one that has to be dealt with down in Springfield. So for anyone who believes that this act is deficient or that certain aspects of the act are deficient, and that whatever its good intentions are, it doesn't necessarily achieve that. The best approach would be to seek your legislators downstate and get them to get on board with the village's position.
So as a home rule community, in the past, we've been able to make changes in certain things. I'm not suggesting this. We have no control whatsoever regarding this particular act.
Yes, I believe there is a specific preemption language in the act, which limits a home rule community's ability to make changes.
Okay, thank you.
Anyone else? Any other questions? Trustee Page?
Chief, so that we give everyone a fair picture, let's do a compare and contrast. Clear and convincing, discussing retaining or holding somebody. Clear and convincing, what is the standard now? We know what they want it to be. What is it now?
You help me with that one?
The standard, trustee Page, is, I believe it's not specifically enunciated. I believe that it simply is
Yeah.
almost on a case-by-case basis. I wouldn't say it's a preponderance. I wouldn't say it's clear and convincing. It's probably somewhere in between the two. If you have someone who's a known recidivist or someone who is, again, some of the offenses that perhaps I would consider significant, but the statute as currently drafted deems not sufficient to retain someone. I believe the judges have more discretion and the officers have more discretion
Yeah.
than they. So this is
The
taking out that
currency.
level of discretion and putting a very specific, and as the lawyers on this board know, very high bar to establish by clear and convincing evidence?
That's a good question because I researched that and couldn't find the actual answer. But I can tell you this, that moving forward in January, the fact your criminal history is not going to come into play. The fact that you haven't showed up for court is really not going to come into play. And it's going to have to be overwhelming evidence to keep somebody in there. That's why I think about physical evidence like body camera evidence, fingerprint evidence, those kind of things. It's not going to be just a testimony that we think this person's going to do something bad and again, in the future. So.
You mentioned 48 hours.
Yeah.
What is it now before somebody has to appear in, what is it, bond court, bail
Right.
court?
So they get, so bond court is going to change from a work week to
Right.
every day. Christmas, New Year's, there's bond court every day. So as soon as you arrest somebody, they're going to bond court. And most likely the officer is going to do that. In Cook County, they have that similar system. They had it for a long time, that if you arrest somebody as the officer, you go to bond court with them. And we're moving to that. And when you think about an 8-hour shift, it's not bad. When you think about a 12-hour shift and then you're going to bond court, that's pretty taxing on the officer and the family.
And now there's no time.
Right.
And I would just add, Chief, and this sort of goes back to Trustee Blair's point about the cost. There is a hidden cost in that, because if you have an officer who's at the end of his 12-hour shift and he has to go, he's getting paid overtime for sitting there, and you have a mandatory minimum 3.
Right.
All right, so, if you're paying 3 hours of overtime at a minimum for that officer if he's over his shift.
Right. And if it's an extended court date, court appearance, then you're talking about the officer moving into his sleep time for the next shift and may have to call off for that, which is problematic. And then it's shorting your hiring back.
Tell everybody how long the sleep time is.
Our sleep time,
Uh-huh.
as much as you can get, especially if you're on nights. Yeah,
But mostly like pilots can't fly.
right.
What's
So
our
it's
rule?
not specific, but we
Okay.
like to get the officers at least 8 hours of sleep. So.
Chief, what would you say this is doing to victims?
Right. I mean,
It has a huge impact
Mhm.
on victims. And I would imagine I'm not even imagining, I know this has to add to the anxiety unbelievably.
The most fulfilling part of this job in my career has been able to help victims, right? Especially in tragic situations. You're able to do what you need to do, work hard, put somebody who needs to be in jail. And then the best part of the job is going back to the victim and saying, hey, we were able to do this. This is what's happening. To face that victim in this system, it's going to be really difficult.
We
You're
address the trespassing again, just
Mhm.
for everybody to, so if somebody's at my house and they're sitting on my front lawn and doing whatever it is they want to do, you can't make them move, right?
Right, we would come, and this question was posed to me Monday night. We had a community roll call and somebody asked me, what if somebody is sitting on my front lawn, exact same thing? What would you guys do? We would come and we would actually write the ticket, it'd be a 21-day notice. We would use all our powers of influence to try to get that person to leave. And that's basically what it has been my whole career when I'm in a situation like that. And the officers can do it too. Like, hey, if you don't leave, you're going to be arrested. We don't want to arrest you. Please, just move along. And 99% of the time we're able to be successful, but there is that group of people that you're not going to be able to talk to. So my answer was have a good water sprinkler system and turn on the water and do whatever you can, and the person I was talking to was, well, what if I'm a concealed carry? And that's where I don't want this to go. Right. And it could possibly do that where people are just going to take the law in their own hands. That's the last thing I want to happen. And I told that person, I said, well, yeah, then you will be in jail, right? And this person will be out. So
So basically, there's more wrong with this bill than there was right.
there's a lot of work to be done. Yes.
So if there's nothing else from the board at this time, Trustee Kagan, do you have anything? Okay,
No questions at this time.
thank you very much. Yes, please. And then we're going to
I
go
ju-
ahead if you don't mind, just because
I
I
just
see our
want,
officers standing out in the hallway. We have a 25th anniversary this evening for one of our deputy chiefs. So please go ahead, Trustee Martinez.
I just want to make sure because we just had budget meeting last week. And we're preparing for finalizing the 2023 budget. That you and your his staff has looked at all the potential cost. And if you need to make any revisions, either for training or additional overtime, as Attorney Pat has indicated, or any other things, we should be revisiting this now, not 3 months into the year or 6 months into the year. So I'm suggesting that you look at your budget one more time, especially on training and any additional
Staffing,
costs.
staffing.
And
Okay,
staff.
so
Excuse me.
we'll have our administrator because it's an excellent point. So thank you very much. Administrator Stonich, if you would, please.
Yes, no, we will certainly take that back with Chief Cunningham. I think he's addressed too that he has accounted for several of the costs in terms of training and overtime, but we'll take another look at it. And of course, we will come back to you with recommendations.
Trustee Page, anything else at this time? Trustee Krusek?
I'm not really worried because I'm sure Springfield will be sending us a lot more money to help cover all these costs, so.
Trustee Abbott? Okay, thank you. So we do, thank you again, Chief and Attorney Pat, and really for all the questions. So now we are going to move to what we call the public comment section of our meeting. And what I'd like to be sure is, first of all, thank you for being here very much. And we would like to invite you, if you wish to make a public comment, and I would ask that there's a speaker's card right on the end of the table there with pens. But if you do wish to make a public comment, that you please come up to the podium and just give us your name and your address for the record, please. And then I'm going to ask that we have a process that we do for each and every meeting. And as we're very interested in hearing from you, our neighbors, what we would ask is that you please limit your statements to 3 minutes if you can, okay? And this is when we ask our village attorney to help us kind of keep track of the time. If you do need to go over just by a minute, we understand. But if we have a large group that would like to talk, we want to be sure to hear from everyone that is here, okay? So if you wish to make a comment or have a question or something you would like to address with the village board on this subject matter, we would invite you up to the podium, please. That's okay. Good evening, John.
John Sealander, 8140.
Mr. Sealander, if you could use the podium, Mike.
John Sealander, 8141 Meadowood Avenue. Thank you for this time. Thank you for doing this. I'm going to give you comments because there's not time for questions, and you've answered a lot of them. Thank you for answering the questions and asking the questions. One, spell out what this is going to cost to the citizens. Give us the school board is arguing in 66 and it's going to cost this much and it's going to cost me $650 a year. Tell us what that is so we can get angry. Okay. And maybe you don't want us angry, but we need people talking down to Springfield. Somebody's got to tell these people they're crazy. I hope the village does a postmortem and sometime next year, 5 months, 6 months into this, say, guess what? This is how many repeat crimes have happened. This, keep lots of track. I hope you're keeping lots of track of how this is negatively affecting us so that we can go back to Springfield and say, thanks. This is what it's cost the citizens. And the last thing is, I mean, our congressperson sponsored this bill and Stava Murray sponsored this bill. She wanted this thing. Use that at the election.
Thank you very much. Anyone else that would like to make a comment or has a question?
Mayor.
Yes, Frank?
My name is Frank Fletcher Brochek. I live in Woodridge. I have been following this matter since its inception. I have attended many meetings. I've attended many meetings where circuit court judges and Supreme Court judges have presented themselves to us. If you, Marianne, and your husband have to go out in your front or rear lawn to stop somebody from being on your property, as the chief describes, regardless of the time of year, with water, skunk oil. I want you to understand that this is chaos. Place that word on your mind if this bill goes into effect, and we can't call the police to assure ourselves of the privacy that we expect as property owners in this state. This would be chaos. There's all kinds of things that my neighbors would do, that they have told me they would do. This is not what your department is expecting. This is not what this village is expecting. Thank you.
And I would ask you both just to fill out a speaker card, just so we have it, if you could.
Yes,
Thank
thank you very much.
Not right this second, but before you go, if you could.
Anyone else? And I just do want to emphasize, Chief, in no way are we having the statement going, please do not call the police. Yes,
Whenever you call, we'll be there and make sure we're doing our best to make sure.
so we still want you, if there's anything, to call 911, please. Okay, thank you very much. Anyone else? Comment, question? If you do want to make a comment, but you don't want to come up to the podium, please, if you would fill out the card. That is something that we will then review. It is part of our public comment and we would put that in our record. Okay, thank you very much. As seeing no one else wants to come up for public comment this evening, again, thank you very much for being here. We will now conclude the public comment portion of the meeting, and I'm going to ask our trustees with regards to the Safety Act presentation. And I know we've gone through questions already, but it does lead us to a resolution that we are considering. And we did have copies of other communities that have put forth a resolution, just sharing, again, our concerns. And what I would ask, just in the respect of time, that we can have discussion, but if you have an opportunity and you would like to share your thoughts, to please put either your ideas, comments in writing to share and be as specific as you can be, because the resolution is a work in progress. And what we would ask is, again, our legislators to take action immediately in this veto session. We've already been working as a community through, thankfully, the chief and our officers, through the Illinois Chiefs Association, through the DuPage mayors and managers. I'm probably forgetting one, Al. That's right, in the Illinois Municipal League. We have been working on this feverishly, along with many other of our neighboring communities. So I would just want everyone to know, but also I do want to again invite, I'll do this one more time. If you feel called to action, please reach out to our legislators. This is important and it is imperative, and our voices need to be shared. And I think the more voices, the better chance that we will all be heard. So in saying that, as a community, we are all stakeholders. So I just want to emphasize, there's absolutely an open door to come into the village. You can call me directly. You can reach out to the trustees here. Please do not hesitate. We want to hear from you on any subject matter, first of all, but this really right now is of a very extreme urgency at this point. So saying all of that, if there's nothing further for us to discuss this evening with regards to the Safety Act, I would ask please for a motion to adjourn our village study board session.
So moved.
Thank you very much, Trustee Krusek. A second, please.
Second.
Thank you, Trustee Blair. All those in favor, please sign aye.
Aye.
Anyone not in favor? Didn't think so. The time is 7:20 p.m. and we are adjourned. Thank you again very much for being here this evening. And if you do have a comment that you would like to leave, please take a card and you can just drop it off here.